we say, Modupe. Today we are looking at a very critical aspect of the contract of sale of goods. We are looking at mistake. And before I'll move on into the full lecture, let me pause and inquire from you if you are a member of our community. If you are not a member of our community, I enjoin you to kindly do so by subscribing to our channel. You will do that by simply clicking on the subscribe button and you'll be automatically subscribed to our channel. This will enable you to have our videos as they drop, and any other freebies available to our community members, they would be yours as well. We'd like to also enjoin you to share this video to others, and if you have enjoyed them in any way, please kindly give us a thumb up by way of encouragement. And then you need to get in touch with us. Please do so by reaching out to us in the comment section. Thank you very much. So like I said, we are looking at an aspect of the contract of sale of goods today, particularly the mistake. So a mistake is actually a situation whereby a party or parties enter into a contract under a false belief about either a fact or law. So why is mistake important in the contract of sale of goods? It is because in commercial transactions, mistakes can undermine the foundation of a contract. Mistake may go to the foundation of the contract, and when a mistake is germane enough or serious enough, it can actually cause a contract to be void or voidable, and this would affect the position or obligations of parties, and even the remedies that they may seek out of the contract altogether. You need to remember that a mistake goes to the root of the contract. Now, minor mistakes like minor misunderstandings do not usually go to the root of the contract enough to make a contract void, but a mistake does make a contract either void or voidable. We'll now look at the definition and scope of mistake. A mistake is an erroneous belief at the time of contracting. So a mistake occurs at the time of the making of a contract. In a sale of good contract, there are common mistakes that may occur. These mistakes include identity of goods, e.g., you are thinking you are buying gold when it is actually silver and not gold. Another common mistake is mistake as to the existence of the goods. So goods are destroyed before the contract, unknown to either of the parties. This could be a mistake. Then mistake in terms of the title. The seller does not own the goods, but he's mistaken as to his title to the goods. Then you can have mistake in terms of obligation, the terms of the contract or the obligation of the parties to the contract. So misunderstanding of what the contract inquires. Now this effect, the effect of a mistake depends on the type of mistake and its impact on the contract validity. We'll now look at the types of mistake that we have. And the first type of mistake that we are going to look at is the common mistake. The common mistake. Now, under this, you will see that both parties share the same erroneous belief. So that's why that mistake is common to the two parties. An example is given where both think a cargo of rice exists when it was destroyed by fire is a common mistake. The effect of this is that the contract may be void ab initio. A good case is that of Bell versus Lever Brothers Limited. Citation supplied. You also find the case of Okonkwo versus Odogu. Citation also supplied on your screen. Another example of mistake is mutual mistake. Mutual mistake. Now, this is a situation where parties are at cross purposes. They are at cross purposes. Each thinks something different from the other. That's a mutual mistake. And an example is where seller thinks he's selling corn and buyer thinks he's buying wheat. So that's a mutual mistake. And the authority for this is Raffles versus Witcher House. The citation supplied on the screen. What's the effect of a mutual mistake? Contract void for lack of meeting of mind. That means that there was no consensus ad idem between the contracting parties. There was no meeting of the mind, since each of them thought that they were contracting on an entirely different subject matter. Like in the example we gave, where seller is thinking he's selling corn and buyer is thinking he is buying wheat. Then we'll also look at unilateral mistake. Unilateral mistake. Now, as the name implies, in this type of mistake, it's only one party that is mistaken. The other party is not mistaken at all. A good example is where the buyer thinks the goods are new and the seller knows that the goods are used. So that is a unilateral mistake on the part of the buyer. And a good example is given in the case of Smith versus Hughes, and you will find the citation supplied on your screen. What is the effect of a unilateral mistake? This generally is valid unless the other party knew or induced the mistake. So we'll now look at mistake as to identity, mistake relating to identity, mistake relating to existence, and mistake relating to title. In the case of identity, sale of a painting that does not exist, this would make the contract to be void. So in case of existence, goods destroyed before contract cannot exist. That's the effect thereof. Then in relation to title, seller sells goods they do not own. That kind of contract is completely unenforceable, and you see this under authority of Akosile versus Ogidon, citation also supplied on your screen. So now let's look generally at the effect of mistake. The effect of mistake. So we'll look at common or mutual mistake. Here the contract is void ab initio. Then at unilateral, where it is a matter of unilateral mistake, the contract generally is valid unless inequitable. So then the remedies available include rescission, restitution, and compensation where appropriate. The remedies available include rescission, restitution, and compensation where appropriate. Now, let's take a practical example. Now, suppose a seller agrees to sell a specific shipment of like 100 bags of maize. Unknown to both parties, the shipment was destroyed before the contract. Is this a mistake or frustration? Is this a mistake or frustration? Let me hear your answer in the comment section. Let me take the question again. Suppose a seller agrees to sell a specific shipment of 100 bags of maize. Unknown to both parties, the shipment was destroyed before the contract. The question is this a mistake or a frustration? Let me see your answer in the comment section. To wrap up this episode, I will simply give you my recommendations for further readings. You could take a copy of A Sale of Goods Act or Law appropriate to your jurisdiction and take a look at it. You could go through the case of Akosile versus Ogidon, citation given on your screen. You could also look up the case of Okonkwo versus Odogu, citation equally supplied, and the case of Raffles versus Witcher House, citation supplied. The case of Bell versus Lever Brothers Limited, citation supplied. And you can look at Good R on his text on commercial law, particularly the 4th edition. With this, we come to the end of this episode on mistake. Thank you so much for being with us on this episode. If you have enjoyed the episode as much as we did enjoy bringing it to you, enjoying you to share it to others on other platforms, and you are not a member of our community, please kindly do so by clicking on the subscribe button. If you want to answer our question, please do so in the comment section. I want to see your take on it. And if you enjoyed the episode, give us a thumb up.